One of those theories is culpable negligence, which, yes, we know from case law is considered a higher burden of proof than even recklessness.
Well, isn't that interesting, because isn't that a lesser for the vessel homicide?
The opposite. Vessel homicide.
Vessel homicide being the lesser of the manslaughter.
It can be, yes, depending on how the charges are pled. In this particular case, the state chose to charge the defendant with each of those offenses separately. And it's my intention to argue to the jurors that, yes, this evidence is competent, substantial to prove beyond a reasonable doubt that the defendant acted recklessly. However, I am willing and prepared to go the extra step and say, but not only was it reckless, it also rises to the level of, and this is where I get to the point of the way that the state charged the defendant with manslaughter. I charged him with manslaughter by causing the death of Lucy Fernandez through his own culpable negligence, but I also charged him with manslaughter by intentionally committing an act or acts that caused the death of Miss Fernandez. And here, the act or acts was his decision to continue to plow forward as fast as that vessel could go, given the weight that was on that vessel, headlong into a channel marker that he knew was there, with a boat full of 17-year-olds, many of whom had been engaged in consumption of alcohol, so that if, heaven forbid, there's an emergency, their ability to react to it is going to be less, which, in addition, that none of them are wearing life jackets.
You know, you come back to that.
In part because it seemed that the court understood that recklessness is not just the way that you drive your boat, it's all of the factors taken into account.
Well, again, not just the way you drive a boat, but when we talk about all of the factors, it's not a type of contributory negligence, because the girls were drinking or not drinking. You would say, see, I don't know how the ability of the girls to respond or not respond go to the criminality, if it is, of Mr. Pino.
Because if Mr. Pino is on notice that the passengers on his vessel are going to be less able to react in an emergency, but he nevertheless places them in a position where they are going to be facing an emergency, then his decision to consciously disregard their vulnerability goes to him being A, reckless, and B, culpably negligent.
So not taking steps beforehand to prepare all of the circumstances, given all the circumstances, to prepare for a worst case scenario. To anticipate.
When you have precious cargo, when you have vulnerable cargo, if a person is driving with, 100 cartons of eggs, they're going to be a little more careful than if they're driving around with 20 cans of, vegetables. You got to be aware of who your passengers are. And he was acutely aware of who they were, first of all, because he's known many of them for years. Second of all, because he and his wife were supplying many of them with alcohol. And third, because we can see the girls are obviously having a good time, and they've already talked about the fact that they were consuming. I'm not charging him with, providing alcohol to minors. But the fact that that did happen does go to the vulnerability of his passengers, and it means that he has a duty to keep them safe. And could he have maybe done that better by driving slower, by maybe operating his vessel on the proper side of the channel? All of those things are things that go to his culpable negligence. And the concept that...
So he becomes culpably negligent in your argument. And it's gross and flagrant, because it has to be gross and flagrant and apparent, by, for example, not supplying life vests to all girls, by not driving slower. Is that what you...
What I would say, Your Honor, is this. If there was no one on that vessel besides the defendant and his wife, and if his wife was in a life jacket, but he was traveling at this rate of speed following this course that we know down the Cutter Bank Channel and slammed into that channel marker, if God forbid his wife had died, he would be guilty of reckless homicide. He would be guilty of vessel homicide because his decision to operate his vessel in that way, where it was likely that death or great bodily harm would result, was reckless. But what makes this cross that threshold from reckless into culpable negligence is the fact that the boat wasn't just with one other person. And the other people on that vessel were not wearing life jackets. The people on that vessel were minors. The people on that vessel, many of them, had been consuming alcohol. The defendant himself admits that he had been consuming alcohol. And so that's what makes this, for lack of a better term, reckless plus. And that is why the state charged him not just with vessel homicide, but also with manslaughter. Also factoring in, forget about the navigational rules for a charge of vessel homicide. But we know what they are. The jury's heard evidence of it. The court obviously can take judicial notice of what the navigational rules are. And then when we compound that recklessness with the fact that he is obviously not keeping lookout, when we compound it with the fact that he's operating at a speed that's not safe, that he did not do anything to avoid A, the risk of a collision, or B, to avoid the collision itself, that's what places this case in the category of reckless plus. And that's why the state submits, Judge, that viewing the light most favorable to the state, this court has to deny the motion for a judgment of acquittal.
Yeah, it sort of sounds like she's saying that he actually did intend to run into the piling. Because now she's saying that he turned, went straight ahead, and he took no action as if he intended to do it. But I thought when we started this conversation, we understood that that's not what the state's theory at least was until today. Till today, the theory was he didn't see the piling. If he had, he'd be charged with murder. But it sounds to me like she's now saying, well, maybe he did commit murder.
I'm not sure I interpreted the argument.
Well, what is she saying? That because he'd been there before, he should have known it was there and he should have taken action to avoid it? Okay, as if he knows it's there and he's still driving in a way that is going to put everybody in harm's way with some mens rea. Up till now, I thought their theory was that he just didn't see it. Had he seen it, he obviously would not have kept going to hit it. And when he got, apparently the boat took evasive action within a second or so of striking the piling when it became clear that there was going to be a collision, an elision. So it sounds to me that they're sort of mixing the two concepts. I think that there's no evidence that, as she said, he was blindfolded. And the case law is just super clear. Let's just go to the cases, and these are the instructions that I understand you'll be giving the jury from the Esposito case. Neither carelessness nor ordinary negligence in the operation of a vessel are sufficient to sustain a conviction for vessel homicide. Simple negligence cannot by itself give rise to criminal liability. Quote, the degree of culpability required for a vehicular homicide, vessel homicide, is more than a mere failure to use ordinary care. Speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive. The presence of central nervous system depressants like alcohol in the bloodstream after the crash in and of itself is insufficient to support a finding of reckless operation of a vessel. So you see these cases continue to make clear it's just not enough even to have alcohol in your system is not enough. And here there's no evidence of impairment. The state must prove beyond a reasonable doubt that the act was not the result of momentary lapse of memory, inattention, or mistake of judgment. A finding of simple inattentiveness is woefully insufficient to state a prima facie case of reckless driving, open paren, willful, and wanton driving behavior. That's State versus Esposito, a direct quote. And so you have a standard here that requires some intentional act, but not simply he intended to drive the vessel. We all understand he was intending to operate the vessel. The question is, was he intending to put his passengers in harm's way and intentionally aiming at the marker, which I thought we understood would constitute a depraved heart and could support murder if his intention was to hit the marker. And then the idea that if there's a carton of eggs on board, that somehow changes the duty of care. I think that's the analogy that the state was using. The fact that some of the passengers may be of a younger age or some are intoxicated. Of course, if he hits the piling, whether you're intoxicated or not, whether you're old or young, that could cause serious injury, bodily harm, and death. So again, I think they continue to define the crime by the elision itself. And under their theory, catastrophic injury coupled with an elision equals reckless per se. That's what they're telling you. Ask the state to define a scenario where that wouldn't be the case. Elision plus catastrophic injury. That's what they're relying upon to say that when that happens, it's a crime. But that's not what the case law says, Judge.